Hello, and thank you for allowing me the opportunity to speak to you about some research that I have done in the area of modification of contract and very relevant to what is going on in the Bakken Basin. My name is Christyne Vachon. I am a visiting professor at the University of North Dakota Law School, and I will be continuing on in a tenured track position starting in August, and I look very much forward to that. So today I'm going to talk to you about the Bakken Basin and a recent decision, actually last year, in the U.S. District Court of Florida, deciding that an instant message can modify a contract with a no oral modifications clause. When business is booming, contracts are flying fast and furious, and in recognition of this and coming from private practice, I am also aware that with contracts come little extraneous events that may amount to modifications of those contracts. Therefore, when I saw, in a warmer part of the world, a decision in the District Court of Florida determining that an instant message can actually modify a contract with a no oral modifications clause, that of course drew my attention. So if we take a look at what happened in the CX Digital Media situation, this will help us better understand what the court, or how the court decided to make its decision. CX Digital Media is essentially a linker for individuals or companies that want to do business on the internet. They have a group of contacts that they link up with customers. And so in this case, CX Digital Media's customer was Smoking Everywhere. Smoking Everywhere went to CX Digital Media in order to be able to facilitate links to customer bases. So CX Digital charges Smoking Everywhere a certain amount per sales directed through the internet space. CX Digital provides services that not only link sales, but also create websites for the customers like Smoking Everywhere. So CX Digital and Smoking Everywhere entered into an insertion order, and this is essentially the contract that they originally entered into. As you can see here, the CX Digital direct online customer was Smoking Everywhere. And CX Digital would direct sales to Smoking Everywhere. And what does that mean? It means that when an individual like you or me searches the internet for something related to, in this case, nicotine-free smoking or smoking little gadgets that help reduce nicotine intake, if we do a search on, for instance, Google, CX Digital will create landing pages and then direct us, i.e. the traffic, to Smoking Everywhere so that they can either close deals or offer free incentives. In this case, Smoking Everywhere had free incentives, and so you and I would land on the web page and be able to register for a free incentive that would initially be free, and then if we didn't rescind our interest, would actually enter into a full-on paying agreement. So, just to provide some context, Smoking Everywhere had a bit of a sordid history with regards to claims it had made with regards to these nicotine-free or less nicotine or I should say, products with less nicotine in them. So those claims had not necessarily borne fruit, and this had come to pass several years before, but there was already somewhat of a taint, as the court points out in its decision. So in the insertion order, CX Digital agrees to direct traffic from the internet to Smoking Everywhere. In addition, the maximum number of sales, i.e. you and me, that could be directed per day to Smoking Everywhere, in this insertion order, it was determined were 200 sales. To Smoking Everywhere's website, this was essentially flowing. We'll start over again. CX Digital would direct these 200 sales per day from their website to Smoking Everywhere's website, and then Smoking Everywhere would be able to close the deal. In addition, and notably, in this insertion order, there was a no oral modifications clause. Now, when we're talking about contracts, it's important to draw the distinction between whether it's a service or a goods contract. In this case, it was determined that this is a service contract and therefore was decided under the common law of contracts. I'm going to talk about that decision, but I'm also going to talk about an analysis under the U.C.C. for the sale of goods, because in my determination, this decision and the results of this decision, i.e. the indirect results, will play out in the years to come with regards to sale of goods contract as well. The important thing to focus on, though, when we're talking about contracting in general, and particularly where a situation like the Vachon Basin is happening and we have business going fast and furious, that there is an effort to create reliability in contracting, and this is something that as attorneys we're very familiar with. We try to create reliable contracts that both parties can count on, hence why they have a contract. On the other hand, there's a need for flexibility in contracting. Flexibility to accommodate changes in the business, changes in technology. For instance, instant messaging was not around when the U.C.C. was originally created, so we need to balance, and the court needs to balance, flexibility and reliability with regards to contract law and the actual contracts themselves. I believe that the Florida decision is actually consistent with that effort to create reliability and flexibility in contract law, and therefore becomes a part of the arsenal for a business tool. What were the arguments in this case? It's a district court case, and it has to do with the common law of contracts. CX Digital, the service provider, claimed it is owed payment for customer sales delivered to its client, Smoking Everywhere, for the months of August, and you can see the numbers here, $25,000 essentially, and for September 2009. CX Digital claims that those sales delivered to Smoking Everywhere in August of 2009 were consistent with the insertion order, the original insertion order. Those sales directed to Smoking Everywhere, 1.3 million, CX Digital claims, in September 2009, were consistent with the modified insertion order. On the other hand, Smoking Everywhere claims that the insertion order was breached by CX Digital, so Smoking Everywhere does not owe anything on those sales. CX Digital, in turn, claims that they didn't actually breach the contract. The contract had been modified, and they were providing sales pursuant to that modified contract, i.e. the modified insertion order. So there are two areas of change that occurred but in the insertion order, but I would first like to go over essentially this medium. Some of us, maybe others more than some, are familiar with the instant messaging medium. And the beauty of instant messaging is that it provides quick returns, i.e. we can immediately communicate by our PDAs or even on a computer, a quick note, get a quick response from our friends and also our business colleagues. This is recognized as a new part of business, this instant message medium. And so I've provided for you here in this slide the opening for that day where the claimed modifications occur. Stop there. The call name of PDRAMCX is a representative, an agent for CX Digital. Nick Torres is a representative, an agent for Smoking Everywhere. Both of them are able to bind their companies, so that was not even an issue that came up in the court's decision. So through the instant message medium, there was on September 2nd, there was a great deal of communication that occurred between these two men, one from CX Digital, the other from Smoking Everywhere. The first change that occurred through the instant messaging medium that CX Digital claims actually modified the insertion order was that they changed the initial landing page, the initial website page that was created for Smoking Everywhere, to two new web pages, and they canceled out the old web page. In the process, we see, if you look at the court's decision, back and forth between the two individuals representing CX Digital and Smoking Everywhere, discussing how to implement these two new web pages and actually troubleshooting to make these two web pages functional. It's this troubleshooting that is of particular note when we have a discussion in a moment, because it indicates that there were efforts on both parties to actually make these two new web pages functional. In particular, Smoking Everywhere contacts CX Digital and mentions it's not working, what's going on, let's fix it. So that's the first change. The first change changes the first website in the insertion order to two new web pages. The second change is that immediately after the change to the two new web pages occurred, CX Digital representative, PEDRAMCX, I wouldn't know how to say that out loud, but he emails, or instant messages Smoking Everywhere, Nick Touris, and says, this is the dialogue, I have it up for you. But in a nutshell, we notice the type of traffic you're getting, and we would like to increase it from 200. Remember, the original insertion order said 200 sales, or here, orders per day, to 2,000. And they think that they can provide that solid sales from 200 to 2,000 per day to Smoking Everywhere. So we get some back and forth here, and actually Smoking Everywhere comes back with no limit. So not only do we have the CX Digital, the service provider, asking to increase the limit, so the offer here would be 2,000 per day, we have the counter offer from Smoking Everywhere of no limit, or counter modification, as CX Digital would claim, of no limit, and an assent from CX Digital of awesome. So when the court analyzed this, awesome was considered an agreement to the no limit amount. That same day, September 2nd, we see a substantial increase of sales directed from CX Digital to Smoking Everywhere's two new websites. And note that there was no complaint. In fact, there were efforts on both parties after these instant messages were exchanged to make the process mistake-free. So in the decision by the court, the Florida court, in CX Digital, the court decided that an instant message is a writing. And so this is quite notable for many reasons, but in particular that when we run into situations where a writing is required, whether it's in mere formation of the initial contract or with issues regarding waiver or modification, this court has determined that an instant message is a writing. We don't, this area is a new area of law as we're talking about emails, instant messaging, and texting. We're breaking new ground with contract law. The second big point to take away from this is the contract with a no oral modifications clause had been modified by the instant messages. This isn't entirely surprising because under the common law of contracts, a no oral modifications clause may be included in the contract but does not carry much weight. Therefore, contracts are allowed to be modified with a no oral modification clause with oral modifications. So even though the court had arrived at the decision that an instant message is a writing, the contract could have been modified if the instant message was considered an oral communication instead of a written communication. The court basically decided first that an oral agreement is sufficient to modify or rescind a contract, notwithstanding a no oral modifications clause, the NOM clause. Secondly, the modification by instant message exchange was not oral, it was in writing. And three, even if the no oral modification clause had effect, Smoking Everywhere would have waived the no oral modifications clause based on their conduct and CX Digital's reliance on smoking everywhere's conduct. Smoking everywhere's conduct being the play back and forth and trying to get the websites and the delivery of the increased number of sales to the websites functional, so they went back and forth in instant message. In addition, Smoking Everywhere failed to complain about the 2 new websites and the increased number of sales. As the court rightfully noted, and I believe this is true, that Smoking Everywhere's conduct led to a modification, and that it makes it very, very hard for anyone to understand how Smoking Everywhere did not intend to actually have the 2 new websites and the increased number of sales to that, combined with the failure to complain. So, CX Digital, the decision was under the law of contract, the common law of contract. My question further was, what happens under the U.C.C. Article 2, sale of goods? Although this decision was made under the common law of contract, the U.C.C. allows for the common law of contract to apply in this situation. In particular, if we start our analysis and look at Section 1-103 of the U.C.C., we'll note that it allows for principles of law and equity to supplement the provisions of the U.C.C. At the time the U.C.C. was created, it was not intended to be all-encompassing. It was intended to codify and make more uniform, and some would argue clarity, provide clarity. Some would argue that the clarity is missing. But in any case, codify, clarify, and make more uniform those laws related to the sale of goods, when we're talking about Article 2 in particular. The U.C.C., though, was not intended to be a one-stop shop. It wasn't intended to provide all the necessary laws related to the sale of goods. Instead, it was to provide a general structure with rigidity and flexibility so that if the law needs to be adapted, or in this case the technology is changing, we can accommodate that in there. One of the means by which this can happen is through Section 1-103. And it allows a court, or in our case in practicing, allows us to look at not only the common law related to the U.C.C. Article 2, but since there is no answer there, particularly in this case with regards to instant messaging, we can look further to the common law of contracts in general and equity. And in that case, this decision, the CX Digital decision, whether it was in North Dakota or in Florida, has some weight here. In this case, it could be said that the CX Digital will help fill some gaps left in Article 2 of the U.C.C. In addition, we also should be paying attention to, as we look to interpretation, Section 1-102 of the U.C.C. And this sets the tone for us, and it basically tells us that this act shall be liberally construed and applied to promote its underlying purposes. So I've highlighted here key terms for you, and it's to simplify, clarify, and modernize the law governing commercial transactions. So if we're talking about modern techniques, instant messaging is one of them. So to be able to accommodate modifications in an instant message, that could be an example of the modernization in the U.C.C. In addition, subsection B of 1-102 permits the continued expansion of commercial practices, also similarly related to this situation with the instant message exchange. And so it begs looking at custom, usage, and agreement of the parties. And also to make the law uniform amongst the jurisdictions. Therefore, it allows, in the case of North Dakota, the Vachon Basin courts and others to look at laws outside of the area, outside of the state, even Florida. We do know, just from Section 1 of 2-209, that no consideration is required for modification of a contract under the U.C.C. Article 2. This is not the case under the common law of contracts, so this is one notable difference. However, there is, like the common law of contracts, a requirement for good faith in these modifications. Another difference with the common law of contracts is that no oral modifications clauses have weight under the U.C.C. Article 2. For both this reason, the effect of the no oral modifications clause and the lack of clarity, and in some descriptions the rigidity, the antiquated rigidity of Section 2-209, we may find that modification under the U.C.C. Article 2 is more difficult to achieve than under the common law of contracts. This is interesting in light of the fact that in general, under the U.C.C. Article 2, the tendency to look for and find a contract errs on the side of finding a contract, whereas under the common law of contracts, it's more of an uphill battle, shall we say. In my analysis, I chose to look particularly at this no oral modifications clause with regards to a situation like we see in CX Digital. But let's imagine it out in the Vachon Basin. Instead of with regards to services being provided from CX Digital via the internet to smoking everywhere, let's imagine that they're situated out in the Vachon Basin, and instead somebody is actually providing construction services to build an apartment or a hotel, which is occurring right now, and trying to keep speed with the number of individuals coming to the Vachon Basin area. What is excluded under the no oral modifications clause? Let's take a look at that. It's subsection 2. Any indication of modification that is oral is excluded. Even written modifications that are not signed are excluded under the no oral modifications clause. So let's take a look at this. Approach 1, applying the CX Digital decision. Is it a signed and written document or exchange in this case? That's the key issue. So CX Digital decision held that an instant message is a writing. So that takes us halfway there with regards to trumping that no oral modifications clause. Finding of a signature under the U.C.C. is a broader definition than what we think of as a plain Jane or plain John Hancock. If we look to Section 1-20137, we may be able to consider the username or call name for the instant message, such as Nick Torres, as a signature. If that were the case, we actually have a writing that is signed, creating a written signed modification of the insertion order. If that approach didn't work, I've looked at a few others. Approach 2, the party's course of performance, so that's the course of performance as identified in Section 1-303 of the U.C.C., modified the contract. If we take a look, the comments of Section 2-209 and Section 2-207, which I don't have up here, allow for course of performance to actually amount to a potential modification of the contract. But once again, as I mentioned before, interpretation of this application is inconsistent among jurisdictions, so we're not guaranteed that this approach would necessarily happen. Two other approaches I would like to pursue relate to Section 2-209, Section 4. So if we look back at that, Section 4 says if an attempted modification fails under 2 or 3, so under the private and public statute of frauds, it may amount to a waiver. Okay, so my approach number 3 says that through the course of performance, so the parties entering into this instant message exchange, they work to get the two new websites functional. Not only that, they troubleshoot on that issue, and then they seek to increase the number of sales to those new websites and have subsequent troubleshooting, in addition to which there's no complaint by Smoking Everywhere on these issues, even after receiving the bill for August or September. So that conduct, whether it's course of performance or performance in general, may amount to a waiver of the specific provisions of the agreement. For instance, with regards to the website itself, or with regards to the volume of sales that are delivered to the websites or website. Both of these could be modified by the actual performance of the individuals in the contracting. Second approach, or excuse me, the fourth approach under this waiver analysis is that the waiver of the no oral modifications clause may have occurred. So if the conduct of the parties could be determined that the no oral modifications clause was modified, and we have jurisdictions that follow this approach, I did not see one of those in North Dakota. There aren't very many cases in this area in North Dakota. The waiver of the no oral modifications clause may have been waived by their actual course of performance. If the no oral modifications clause is waived, even an oral communication that's not signed, not in writing, could amount to a modification of the specific, or I should say other specific provisions of the agreement, i.e. volume of sales and website. Therefore, if it's determined that the no oral modification clause has been waived, the no oral modifications clause no longer applies, and those specific provisions of website and volume can be modified without a writing and without a signature. I thought it was worth noting that Section 2-209 has a comment in it that indicates this section seeks to protect and make effective all necessary and desirable modifications of sales contracts without regard to the technicalities which at present hamper such adjustments. I believe that this comment says it all, that essentially the CX Digital decision would support this commentary and therefore be applicable under the approach that I have recommended, or the four approaches that I have recommended. Going forward, with regards to practice, what would I recommend? First of all, noting that CX Digital, and if there are any progeny, do balance the need for reliability and flexibility in contracting, whether it has to do with the common law of contracts or Article 2 under the U.C.C. First of all, as many of us who have had the experience, we know we need to inform our clients about the no oral modifications clause, not just about its existence, but the implications for that. In practice, I've noticed that clients tend to forget, or maybe, shall we say, intentionally forget about the no oral modifications clause as they're trying to make business happen left and right, i.e. Boomtown. It may be convenient for them to ignore the no oral modifications clause in a contract and then proceed as such. Therefore, you would have to indicate what the state of the law is so that at least your clients can appreciate the implications for what they do if they continue in the instant messaging medium. A second recommendation that I make as to this, the results of this case is to add language to the no oral modifications clause. Of course, we are in a constant effort to reduce the language we like to add into contracts, but in this case it might make sense to add language to the no oral modifications clause that such communication mediums as instant messaging and email do not fall under modifications. I would also say texting in that category, so email, instant message, and texting, just to exclude those so that there is no particular issue. Although your client may want that flexibility if they're in a situation like Boomtown, but to be informed about it. here's the site for the actual decision. And you are welcome to reach out to me, shoot me an email, contact me if you have any questions or comments. And I very much appreciate the opportunity to speak to you. And I wish I could be there for this actual conference, because I'm sure there are fascinating presentations out there. And I've actually never been to Bismarck yet. Thank you.